Hi everyone, I'm Ethen Chang, and in today's video we are going to discuss about the case of Loh Siew and Nagashawaran anak lelaki Bumiadi, the intervention of Majlis Agama Islam and Adat Istiadat Melayu Perlis, and its effect towards the development of LRA, the Marriage and Divorce Act 1976.
In this case, Majlis Agama Islam and Adat Istiadat Perlis filed an application to vary the court order that was granted by the High Court in March of 2021. This order involved 3 children of the petitioner, who was the wife, and the husband, who was the respondent. The petitioner and the respondent was married on the 25th of May 2008 under the Law Reform Act. However, the marriage came to an end in July 2020, and the respondent, without the consent of the petitioner, facilitated the conversion of the 3 children from Hinduism to Islam. The petitioner obtained a court order that allowed her the full custody of her children. However, the children was taken into the custody of a third party, and the petitioner was denied the rights to meet her children. Subsequently, the petitioner filed a habeas corpus application to the High Court, which the High Court allowed, and the petitioner was reunited with her children. Subsequently, MAIPs filed an application to intervene the court order in order to vary the court order that was granted by the High Court.
The court laid following issues to be followed. Firstly, whether MAIPs is a Muslim. Secondly, whether MAIP has an interest on the conversion that was held as invalid. Thirdly, whether MAIP's application should be allowed if the court holds that the children in fact are Muslims.
Now we will discuss on the decision in the present case with reference to the case of Pendaftar Mualaf Wilayah Persekutuan and Lee Chang and others, and another appeal in 2022. In Pendaftar Mualaf Wilayah Persekutuan and Lee Chang and others, and another appeal in 2022, the case is about the unilateral conversion, where one of the issue of the case was whether the consent of both parents, i.e. the first respondent and Alina, who is the first applicant, is required before the COC, which is the certificates of conversion to Islam, can be issued in respect of their underage children. In the case of Tioh Engkwat and Kadi Pasir Mas, and another in 1990, we will opine that the decision of the case was legitimate, as in the principle of the stare decisis, where the High Court and High Court of Appeal were bound to follow suit the verdict of the Indira Gandhi case. There were also cases where the consent of both parents is required to legally convert the minor children. We need to consider that the minor is still under the duty of the parents or guardian to make a decision, as they have yet to reach the age of majority, which is 18 years old, in accordance with the Age of Majority Act 1971, as in Article 12, Clause 4, where it states that a person below the age of 18 should have their religion decided by the parents or guardian. Another aspect we would like to accentuate in support of our argument is that children are assumed to lack the ability to make reasonable decisions. This is where the position of guardian or parent comes into play, as parents are far more sensible and mature when it comes to making decisions for their children. The rationale for both parents reaching an agreement would be to avoid disagreement and different viewpoints concerning their children's future. Back to our case, Loh Siew and Nagashawaran anak lelaki Bumiadi, we wish to emphasize that unilateral conversion to Hinduism from Hinduism to Islam is illegal and not recognized by the law.
Okay, so the next effect as to the present case is the involvement of both parents as a prerequisite terms for conversion of a religion of a child. So to start on these facts, I'll be starting on the case of Indira Gandhi against Pengarah Jabatan Agama Islam Perak. So in 2009, a Hindu mother of 3 children named Indira Gandhi had a conflict with her husband, thus bringing the issue to the court. The issue arose as to whether when the husband took the youngest daughter of 11 months, and it is further issue that Indira learned that the husband had converted all the 3 of their children to Islam without her knowledge and consent. Indira then brought up the issue to the court to reject the unilateral conversion of her children and obtain custody of them. However, the High Court had in favour of Indira Gandhi, reversing the conversion certificates and granting her custody. And it was further issued that the High Court decision was reversed by the Court of Appeal, and eventually this case was brought to the Federal Court. In the recent case of Loh Siew is whether both the mother and the father if both are still surviving of a child of a civil marriage, must give consent before a certificate of conversion to Islam could be issued. So according to the judgment given by Zainul Ali, Federal Court Judge, it is stated that where a decision of such significance as the conversion of a child is made, it is undoubtedly in the best interest of the child that the consent of both parents must be sought. The contrary approach of allowing the child to be converted on the consent of only one parent would give rise to practical conundrums. In the case of Chang Ahmi against Jabatan Hal Ehwal Agama Islam, Majlis Agama Islam Sabah, the facts is that the father adopted Islam as his religion and afterwards converted the daughter, who was 2 years old, without the mother's permission. The mother then requested that the declaration of her daughter's conversion to be deemed invalid. The only issue arises which found to be questionable is in regards to the interpretation made by Justice Ian Chin. Notice the term parents, as mentioned in the enactment, is in the plural, which literal and ordinary interpretation means the father and the mother, thus letter he. He did acknowledge that Article 124 of the Federal Constitution speaks of parent in singular form. Therefore, throughout the trial, the court still held on to the interpretation of in plural forms, which included both the father and mother. Contrary, in the case of Shamala Satya Silan against Dr. Jega Nagesh Mogaraja, the wife requested a declaration from the Civil High Court that her husband's decision to convert her 2 children to Islam without her knowledge or consent was void. The Civil High Court found that on the construction of Article 124 of the Federal Constitution, read in conjunction with S. 95B of the Administration of Islamic Law, Federal Territories Act, both of which use the singular word parent without S. The consent of a single parent therefore was enough to validate the conversion of a minor to Islam. However, in the light of the latter case, Zainul Ali, Federal Court Judge, further emphasized that since custody of the children had been granted to the appellant, it was the appellant who exercised the dominant influence in their lives. To allow the other spouse to unilaterally convert the children without the appellant's consent would amount to a serious interference with the lifestyle of the family. So the statement basically established a view that in case of such, the fact relies on who held the custody as to whether the father or the mother that the children grew up with. As per the case of Indira Gandhi, it was the mother who influenced dominantly more than the father. Thus, such act of conversion by the father without consent of the appellant is adequate, as it may bring chaos to the way of the children used to live.
Now, we move to the judgment of the case. Concerning the first issue, the court is agreed with the petitioner's contention that MAIPs was not a person within the definition provided under Section 3 of the Law Reform Act. The court stated that although the Law Reform Act does not define the word person according to Section 3 of the Interpretation Acts 1948 and 1967, a person includes a body of persons corporate or unincorporated. Concerning the second issue, the citing of the federal court's case of Indira Gandhi, anak perempuan Mutu, and Marah Jabatan Agama Islam and others, held that the law as it stands is undeniably that unilateral conversions are illegal and not valid. Therefore, the court held that it was bound to follow the decision of the federal court in the Indira Gandhi case under the doctrine of stare decisis. Concerning the third issue, the court held that even if the children were in fact Muslims, the application for leave would still be dismissed. The court held that MAIPs was not an interest person as pursuant to the above provision. The duty of the MAIPs itself was only to the Muslim community in the state of Perlis. Since the children reside in Selangor, there is no connection between them and MAIPs. The court emphasized that the relationship between the parent and the children is sacred and should not be subjected to the intrusion of the third parties.
Assalamualaikum. Waalaikumsalam. Boleh saya tahu apa urusan cik datang sini?
Okay, so hari ni saya ingat nak urus nak convert anak saya masuk Islam.
Boleh cik, untuk urusan convert ni saya akan tanya dululah anak cik. Adik faham pasal Islam?
Faham?
Boleh kita ikut bersyahadat ya?
Boleh.
Okey, baik.
Mrs. Petitioner, could you please explain the event leading to the custody dispute?
Young Arif, me and my husband were married in 2008. But in July 2020, our marriage came to an end, and my husband facilitated the conversion of our children without my consent.
Young Arif, I only wanted to give my children spiritual guidance. I just want my children back.
Despite your intention, the court grants sole custody to Mrs. Petitioner in the light of these actions.
Please, let me see my children.
Sorry, I cannot allow that. They're under my care now.
The court hereby grants a habeas corpus application reuniting the children with their mother, Mrs. Petitioner.
Young Arif, as a MAIPs representative, we seek to intervene in this matter. Young Arif, I think that the petitioner should not have the full custody on the children, because I don't think that the petitioner have the capability to take care of her Muslim children. Young Arif.
Yeah, Arif, MAIPs shouldn't intervene. They don't fit the definition of a person under the section of Law Reform Act. Being an Islamic entity, they are barred of such application under Section 3 of the Law Reform Act.
Young Arif, Nazira has taken my children and is preventing me from seeing them.
Hence, I thank all parties, and the court will consider these arguments before making a decision.